Hello, everyone. Thank you for joining me for today's video. I am doing this video right after a Zoom consultation with a potential client because the questions, I think, come up quite often, and it will be I think it's a good video topic. So the question is, why didn't the mortgage company notify me as one of the heirs of my mother or my father when they were about to do a foreclosure? And the question is, why didn't the mortgage company notify me as an heir to my parent that died while they were trying to do a foreclosure sale? And now the foreclosure has already happened. This question seems simple on the surface, but it's actually a loaded one, because once we got into talking a little bit more during the consultation, I found out that the heir, the person that I was talking to, actually believes that the mortgage company didn't even know that the parent had passed away. His father had passed away. So then the question is, are they supposed to notify heirs before doing a foreclosure? Yes, and it depends. So yes, they're supposed to notify the heirs to a deceased person before they would move forward with a foreclosure sale. But what if they didn't know that the person is deceased? Then there's no obligation to notify the heirs. So that's a quick answer to the question that came up in this particular situation. In other cases, sometimes the mortgage lender might have been notified by the heirs that their father or mother had died. If indeed the mortgage company was notified properly, meaning that typically they would request the copy of the death certificate from the heirs, and if the heirs followed up with that process and sent the required documentation in, if the heirs actually followed up properly and sent all the required documentation to prove that their father or mother died, then the mortgage company is under an obligation to make sure they notify the potential heirs and the heirs that are known of a potential foreclosure sale. So yes and no in a way. Yes, if they knew that the person died, then of course they're supposed to notify the heirs or the known heirs. And if they don't know of any heirs, some of these lenders take a gamble and go through a non-judicial foreclosure process anyway. But the best practice is to go through a judicial foreclosure process in that case, because the state of Texas allows lenders to go through either a non-judicial process or a judicial foreclosure sale process, depending on the type of loan. Most of the loans are conventional or regular loans that are not anything to do with a home equity or to do with a reverse mortgage, and those can easily go through a non-judicial foreclosure sale. And the difference between non-judicial and judicial is that they can do a foreclosure sale without involving a court or a judge. That's the non-judicial. And then the judicial process requires them to file a lawsuit and go through a court process where a judge would oversee the proceedings, make sure everything is done according to the law, hopefully, and keep an eye out for the estate or the heirs to that person that has died. So the judicial process is always available, and the lenders can choose to do that, but most of the time they will choose a non-judicial process if the law would allow them, because it's an easier process for them, it's cheaper for them, it's faster for them, and they don't have to be put under a microscope by a judge. So they will always pick the non-judicial process if they can get away with it. And so this particular potential client that I was speaking with was very upset because the foreclosure sale already took place. But the thing is, he was living on the property and he knew, of course, that his father had died, and I don't think, notified the mortgage lender. At least he didn't say that he did when I asked him. So you would always want to notify the mortgage lender as soon as possible. Once you have the copy of the death certificate from the funeral home or from the county's office, the county clerk, you can then forward that to the mortgage company if you are really wanting them to know that a relative has died and you don't want them to do anything shady or anything that could adversely affect your interests while you're still trying to figure out how to take care of the mortgage. So that's really my tip for people that are finding themselves in this sort of situation. So once you notify them, they're now under obligation to follow the law, and make sure they notify the heirs before they do anything drastic. If they do not notify you, then you'll have a recourse to try to reverse that foreclosure sale. And we can help with that. And you can find a lawyer in your county. A real estate lawyer in your county can also help you with that, most likely. This is strictly regarding Texas law. In other states, all foreclosures will go through a judicial foreclosure process, for instance. And in some states, they can all go through non-judicial foreclosure process, with the exception of very few. So Texas allows both, which is kind of confusing for people. But if you would do a consultation with a real estate attorney or foreclosure attorney, they can point you in the right direction. And so what else can you do if you have a parent die suddenly and you are now trying to make sure that there is no foreclosure on that property because there's a mortgage? I would say you have to submit immediately not only the copy of the death certificate, but also submit a request, as an interested party, as an heir. Submit a request for the mortgage statement so that you can see what's the status, and also submit a request for a payoff quote, because the payoff quote will tell you the total amount that's still owed on that loan. And then you and your family members can try to figure out how you can pay off the mortgage. You do have a few number of months to be able to do that as an heir. They don't then move forward with a foreclosure sale, because you can tell them, oh, we intend to pay off this loan so that we as a family can keep the property. So you have a few months, typically 6 months. You can try your best to figure out a way to get money together and pay off that loan. So that's one option that you have. The other option that you have, if there's only maybe one heir, or if there are two heirs involved, this option is easier in that way, because you can start trying to assume the loan. I don't think the mortgage companies are required to give you an assumption of the loan, because most of the time these days the loans are non-assumable, but in some instances they would allow family members to assume the loan anyway, even if it's not an assumable loan. So you could ask them to consider you for an assumption. The difference between trying to get money to pay off the loan and assuming the loan is you don't have to go through a rigorous application process for a new loan. So you would then be qualified more easily when you assume a loan, and the amount that you would assume on that loan is whatever the balance is that's left. So let's say dad had paid off most of the loan that he took out. Maybe he took out a $500,000 mortgage, and now he only owes $60,000 on it. Then you would assume the $60,000 balance, and then you'd be paying it on a monthly schedule instead of having to pay it off all at once. When you apply for that, they would send you a list of documents that you need to be able to be considered for it. And then you have to be considered. It doesn't mean that you will be approved, but at least they'll start considering you. And what that does is it gives you more time to figure out other options. So those are the two that are available to you. The third option is available to whoever it is that's designated as the executor of the estate or the administrator of the estate. So let's say dad had died and he had a will. Normally the will would name an executor for that for the estate. That person has a lot of standing just automatically by submitting the documents to the mortgage company saying, okay, I was listed as the executor of the estate, but the best practice, the most persuasive way is to start a probate case in a probate court where the judge in that court issues an order designating you as an executor, because the will alone is just a piece of paper until it's admitted into probate. It's not necessarily final. So you'll have to submit it to a probate court. The probate court would say, yes, this person is designated as the executor. And that order is what you'll submit to the mortgage company, letting them know that you are in charge of the estate for your father. And so they will speak to you more and they will listen to you more. Let's say when you have that designated status. The other status that could be designated by a probate court is a designation as administrator of the estate. And you do that typically when there's no will, but you still need to sort out the affairs and the financial aspects of the estate. And you would like to be designated as the administrator, meaning the person in charge. So you could do that, or you could have one of your siblings be the administrator. So it depends on who has more time or more, I guess, business savvy and more patience to deal with all that's involved. And then once you have the court orders, the mortgage companies behave better. Let's just put it that way. It's just the way it is. So my suggestion is if you can get all that, then you can get to what you want faster. So don't just send them the debt certificate and think that that's all you need. You still need to figure out an exit plan for that loan. All right. So this is my video. It's pretty brief, but I think this question is very important. This particular topic is important to a lot of people. And then, like I said, if the mortgage company blows you off or doesn't respond to you as you think they should, you should certainly get a lawyer involved. All right. So let us know if you have any specific questions that are related to Texas. You can send us a message on our website. The information is below this video. If you send us a message, we'll certainly respond to you and try to give you some pointers or even give you recommendations for lawyers in your area that might be able to help. If you're in another state, definitely consult with a lawyer in your state. Don't try to do this alone, especially if it involves property, because that's a huge, huge asset for most people. Okay, so thank you for watching as always. I hope you enjoy your weekend and I will be speaking to you guys soon.